Hey, all right, Shannon, you all right?
Evening, yeah, how are you?
Yeah, pretty good, thanks. So welcome everyone to this evening's live stream. It's just me and Shannon tonight, no Will. We've had a lot of questions coming already, some really good questions, so we're going to get stuck into them pretty soon, excuse me. Usual stuff applies, so don't put personal data into the live chat. The live chat will go down once the recording becomes a recording. I don't quite know how YouTube does it, but it does it at some point. And I think that's pretty much it. It's not legal advice. We're not solicitors. We're just trying to be helpful, trying to give you some information which would hopefully help you out, understand the law a bit better, basically. So we'll try to refer to guidance and case law and stuff where we can. So yeah, let's get on with it. I think contrary to my original plan, Shannon, if we just start with the ones in the live chat, because that person's very, put a lot of good stuff in there. So just there's about 5 questions, having said that, so we'll try and get through it as quick as we can. First question is, does the housing officer have to follow the code of guidance, or is it just guidance and not law, so they don't need to follow it? Really good question. The answer is it's statutory guidance with a big G, and that means that councils, basically within the Housing Act 1996, I can't remember which section it is, it's like section 172 or something, says councils must have regard to any guidance issued by the Secretary of State, which this is. So it's basically legally binding. It's not it's it's official guidance. Let's put it like that. And what that means is, if a council doesn't follow the guidance, then it can you're already in the realm of of basically compensation claims if you took it to the LGO. So there's a lot of really good stuff within the guidance. There are some things within the guidance which basically don't say that councils have to do it. So, for example, one example I can think of off the top of my head is in chapter 17, which is about suitability of accommodation. And it basically says, one of the things it says is councils should basically have regard to pets. I can't remember the exact wording. I could if I could dig it out. And also it says basically where someone's basically trying to deal with their substance use, the council should consider housing them somewhere else so that they can kind of get away from associates. So those would be 2 examples where actually it's not, councils don't have to do it, but elsewhere in the code of guidance it says councils have to do this, they must do that, particularly around section 184 and section 188, which are the 2 key sections of part 7 of the Housing Act, which is all about homelessness. So they have to do it basically. I don't know if you've got anything to add to that one, Shannon.
Just a quick one, actually, because there are lots of guidances out there that aren't like sort of as powerful or as weighty. But when you go on the code of guidance and you go through to the government website, before you sort of get to the download or the chapters, it does say that local housing and social services authorities must have regard to this guidance when exercising their functions relating to people who are homeless or at risk of homelessness. So it's always worth checking just the little bit of like small print at either the end or the beginning of those documents to check sort of how weighty they can be.
Yeah, and I've never had a situation where I've made a complaint and it's gone to the LGO or whatever, and the LGO said, actually, councils don't have to do this. It does get a bit technical around things like protection of property, but that's a whole nother story. So yeah, hopefully that answers that question. It's a really good question. Next question on there is a mental health disability treated the same as a physical disability? So in one sense, yes, and in one sense, no. So obviously, when it comes to considering someone's disability, you have to look at what the person's disability is. So, you wouldn't treat someone with long-term depression as if they were a wheelchair user, for example, just to give a stupid example. So you wouldn't, get them accessible housing because that's not what they need from their disability. But in another sense, they're still disabilities, so they're still absolutely valid and absolutely have to be taken into proper consideration by a council. I think in the real world there probably is less respect for certain disabilities rather than others. So I think I would imagine most housing officers would respect someone with need to use a wheelchair, whereas potentially they would have less regard to things like, as I say, things like depression. I have housing officers say, "Oh, it's just depression, you can't be in priority need," those sorts of things. Those wouldn't be lawful. So yeah, trying to think what else might come into it. So I haven't seen this in practice. I remember doing training where, because the Equality Act doesn't specify it has to be a health issue at all, it just says the word impairment. So potentially where you've got someone who can't read and write, and it's not because they have a learning difficulty or something, then that still may well qualify as an impairment for the purposes of the Act. But again, I haven't seen that kind of in practice, so I don't know how kind of easy it is to make that argument. But that's the way I think the wording of, or the definition of disability is an impairment that has a substantial impact on someone's ability to carry out day-to-day living activities for either a year, or if they're going to live less than a year for the rest of their life. So it has to be like long term. So you might have like acute. We saw this as a question actually in the Facebook group this week about kidney stones. Now I don't know much about kidney stones, but kidney stones would be something which is an acute health issue, but because it's not long term, if it gets treated, then it wouldn't be a disability. So yeah, again, you've got anything to add to that, Shannon?
Yeah, I think partly what the question's getting at as well is like, but there's no sort of hierarchy. There's within sort of law and stuff, you're not more disabled if you've got a physical disability than if you've got a mental health disability, or and vice versa. I think, like you say, it's about how the disability affects you. But we get that quite a lot as well in regards to priority need and sort of, well, what gets me more priority need? And it's not like that. There's no sort of hierarchy of, this condition ticks a box and then you're suddenly more eligible, for example. It's not like that. To just make that point, really.
Yeah. And I think as well, and I've kind of alluded to it already, there are certain mental health issues which in my experience get taken more seriously. So PTSD tends to be kind of taken seriously by housing officers, but personality disorders, which can often be, the same root cause and the same, actually manifest itself in very similar ways, would often not be treated as a serious thing by housing officers. So, in the real world, there is a hierarchy, but there shouldn't be. I think that's kind of probably a good answer. Yeah, cool. Okay. So next question, which is kind of sort of in sequence. So can a mental health disability trigger emergency banding if it is detrimental to the client's health and would be relieved if they were housed? So yes, but I think there's a little bit more to this question. So I'm just going to check the, just bear with me a sec. Yeah, okay, so yeah, there's a sequence of questions. So this actually relates to someone who has been served a Section 21 notice. We're going to assume it's a valid Section 21 notice. The reason I'm hesitating here is that priority banding, is that the word they've used?
Yeah,
emergency banding. So banding, right, it's complicated, but it's worth going into this in detail. Banding is all under Part 6 of the Housing Act. So anyone can apply for social housing. Not everyone is eligible to actually get on the wait list, but anyone can apply. And many people, they might apply because they might be overcrowded, or might be they're under occupying or something. They would be able to apply and they would eventually get banding on the housing register. And if their current medical issues, whether it's mental or physical, were kind of, were kind of significant enough, often evidenced by an OT report, then that would potentially get them increased banding, or potentially the top banding. It just depends on how the council's policy works. So lots of councils will have very different ways of kind of setting out their banding. The reason I'm hesitating is that if you've got a valid Section 21 notice, then you should have, although you may not have, been dealt with under Part 7 of the Housing Act. So the Code of Guidance, which, as we said, is basically legally binding. If you make a Part 6 application, and in the course of filling in those forms on the council's website often, if you give them reasons to believe you might be homeless or threatened with homelessness, it should be taken as a homeless application under Part 7. So it should switch from the Part 6 sort of pathway through to the Part 7 pathway, which is better in most ways. Now, if, under Part 7, if you've got accommodation where, you have a disability and it's been made significantly worse, which is the kind of test set out in a case called Lomax, which was back in 2018. It was a very high threshold, I'd say. So technically, yes, you could be homeless for that reason. If the Section 21 notice has already been served, though, I think in the real world, they probably not. I think technically, if you had an amazing barrister and a really clear-cut case, maybe you could kind of get emergency accommodation sooner. But I think in the real world, they'll just say, well, you know what, it's not, we accept it's not reasonable to continue to occupy, therefore you're homeless, but we're going to keep you there in the short term until we kind of have to step in further down. We talked at length last week with Will about, at what point does a council have to offer temporary accommodation? And legally, it's much sooner in the process than it actually will be, in practice. So councils will often leave it to a much kind of distant point in the eviction process than they should do. And there's not a lot you can do about that unless you've got a solicitor. So, that's my answer to that. I mean, certainly kind of information there. So clients kind of, clearly sounds like they're in and out of psychiatric units, and, kind of, a lot of suicidal ideation there by the look of things. So you're certainly in the ballpark of a disability that might qualify for this. But I think in that Section 21 period, I think it's going to be a real struggle to get moved and get temporary accommodation. You can certainly make the argument. There's no harm in making the argument. And hopefully there'll be a lot of evidence present there in terms of medical records from hospitals and so on. But I think, it's going to be difficult to make a council rehouse you.
I wonder what could be worth doing though. Rather, you might not get that result. Actually, if you can lay out to the council, all right, they have to stay in their accommodation until, temporary accommodation duty kicks in. However, in the meantime, you need to, I don't know, check in with the client once every 2 weeks just to keep the anxiety at bay. You need to make sure everything's in writing to make sure that the PTSD is not being triggered, or however it obviously affects that person. You can potentially, with the mental health team and the other professionals working with them, you can potentially do quite a lot to manage the symptoms. And I know that sounds a bit like firefighting and not really addressing the issue, which is obviously the being homeless. But in that temporary sort of period, setting those realistic sort of expectations and saying, actually, look, this isn't possible. However, council has to do this because they have to make those reasonable adjustments. We can include it in your PHP when it comes to temporary accommodation, exactly what you need. We can't put you in a shared house, for example. So you could spend all of this time now preparing the council in regards to what your temporary accommodation needs to look like when you get there and how they need to be treating you throughout that process. I think that's probably worth putting some effort into, actually.
Exactly. Really good point. And I think, so again, referring back to something we said last week, based on the LJO case I was working on. So it's when you've got someone with a disability, it's really important not just to lay out that they have a disability and spell it out to the council when you're initially from the start, but also you need to spell out what it is the council need to do in response. And with someone who's highly anxious, for example, actually, if a housing officer is really communicative and really kind of accessible and responsive, that may well go quite a long way to actually putting that person's mind at rest and easing that anxiety. So I think that's something you want to do. And a good housing officer would say, okay, well, do you know what? We wouldn't normally kind of check in with you every week, but because you've got this kind of long-standing issue, and because we want to try and alleviate that as much as we can, we're going to be make sure that we update you and just kind of talk through the process. Because I think housing officers have got certainly scores of cases they're dealing with, probably hundreds over the course of a year, and it's it's impossible to do the job legally, basically. So, but a good housing officer will take the time to to kind of make the effort to explain stuff. I remember working in a drug and alcohol service. I had someone working with someone who they had a diagnosis of something like bipolar, I think. And the psychiatrist at the drug and alcohol service, he was amazing. Basically, I was in the doctor's appointment with them, and the doctor, he was just like, "Well, has anyone actually explained what this means?" And she was like, "No, never been told actually what this diagnosis means." So he just spent about 10 minutes just going through all the kind of stuff, and just that in itself, just clearly, just kind of see a weight lifted off her shoulders, and just kind of thinking, okay, this makes a whole lot more sense now. So I think professionals kind of taking the time to explain and not assume that people know how it all works, and taking the time to actually explain that sort of stuff is helpful in itself. So yeah, are you Youssef? Hi, Andrew. Nice to have you here. Hopefully that's dealt with those. Hopefully that's been helpful. I'm just going to go back to a question we had come in through the week, just so that we stay on track a little bit. We're going to try and do our best to answer everything tonight. So this question here, I have a service user who's currently a voluntary patient for assessment and treatment at a psychiatric hospital, having been admitted after a mental health act assessment. They've wrecked their flat, and I was expecting the housing provider, I'm going to guess that means housing association potentially, so social housing landlord, I guess, to work with us to support him back into the property when the repairs have been carried out, as it's currently uninhabitable. However, the landlord has said they're going for immediate possession, but have offered to find temporary accommodation for when they're released from hospital. So it's not actually a question in there, but I think what the question might be is, first of all, can you kind of try and force the landlord to kind of support the person back into that property. And then I guess potentially secondly, you know, what duties are owed to that person once they're released from hospital. So just dealing with that first question first, can you make a social landlord take someone back who's just trashed a property? The answer is probably yes in the very short term, you know, unless there's a closure order or something, you can't prevent someone from accessing their property. But if it's uninhabitable, that doesn't seem to be what's desired here. But I think what you can't stop is a landlord taking action to recover possession of the property as soon as they possibly can, because that's their landlord. They've got a right to do that. And so the fact that the council is basically sort of said, well, actually, you know, we'll find temporary accommodation when when they're released from hospital, that says to me that, interestingly, that first of all, that says that a homeless application has been accepted in terms of that person is threatened with homelessness, they're going to be discharged from hospital at some point, and they're immediately accepting that Section 188 is triggered in terms of there's reasons to believe they might be homeless, might be eligible, might be in priority need. So what should happen is when the person's discharged from hospital, assuming they've then got they've got capacity to make a homeless application, which we talked about extensively in other live streams, then they'll be put in interim accommodation pending the outcome of the Section 184 decision. Just use lots of jargon as much as possible in a short space of time. But the question is probably going to come then down to, are they intentionally homeless? And again, as we've discussed in numerous other live streams, the code of guidance is very, very clear that you are not or an act shouldn't be deliberate. So there's a sequence of kind of things that have to happen for you to be intentionally homeless. One is that the accommodation you left must have been reasonable to continue to occupy, which is a big one in terms of affordability or abuse and whatever. So that could that could immediately mean you can't be found intentionally homeless. But basically it says, in terms of establishing whether someone did something deliberately, if they did something whilst their mental capacity was fluctuating, or if they had an assessed mental health issue or substance use issue or whatever, then it should not be considered deliberate. Therefore, they wouldn't be intentionally homeless. So although you might have someone who, they absolutely trashed the last property they were in, that doesn't mean to say that they're going to necessarily be intentionally homeless. One of the problems they've got, though, is they will probably owe that housing provider thousands of pounds, depending on how much damage they did. It seems to me that housing providers don't get a good deal when it comes to repairs. It seems they get charged for the nose for stuff anyway. But basically that, they're likely to owe the housing association thousands, assuming it is a housing association or whatever. It's private, the same would apply. And what that means is, although the council might then have a duty to house that person down the line, their ability to do that is really limited, because whilst they might nominate that person for a tenancy in a social, on the housing register, basically, housing providers, if they're not the council, which often they won't be, can just say, we're not having that person because they're not a good tenant. So although you've kind of got housing providers saying, no, they're not a good tenant, that doesn't mean to say they're intentionally homeless. So I'm hoping that's explores that, and kind of, as I say, we don't quite know what the question is, but I think that hopefully would answer two of the potential questions that would come out of it. Shannon, have I missed anything?
I don't think so. I mean, it's clutching at straws, really. But again, I'd be potentially using this time and contacting the council, like foreseeing that problem, and going, look, is there any chance we can apply for a DHP to pay off these the charges for the sort of works that need to be done? And I know a lot of areas as well, they might have one, if it is social housing, one main social housing provider, and saying, actually, they're not going to accept this person as a tenant again. Please, can the other smaller housing associations that might have a handful of properties, please can he have, or they have, sort of first pick, or can you keep an eye on those specific ones, or sort of trying to get the council to think outside of the box, because they've obviously been fairly good in terms of accepting the application, like you said, and saying, right, we'll get temporary accommodation when you're released from hospital. So I would be jumping on that goodwill and going, oh my God, you're so amazing, thank you so much. Can we do this? Can we do this? And trying to just iron out those issues whilst you've got a bit of breathing space, and whilst you're not like on the day trying to be bidding and everything else.
Yeah, I mean, absolutely. Because when people are in hospital, it's often a really good time to gather other evidence as well. So, call professionals meetings, But also, as I say, if it's likely, it sounds like it's likely to come down to an intentional homeless decision at some point. So again, just kind of getting, whilst they're in contact with the patient, getting the consultant psychiatrist in the ward to talk about, just their opinion about what that person's capacity was likely to be like. You can't post-date a mental capacity assessment, but you can make an assessment. You can put records together. You can say actually it was likely that this person didn't have mental capacity when they trashed their flat or whatever they were, a psychotic episode or something. So that might just kind of safeguard you for down the line, because it's a lot easier to get that stuff whilst they're in hospital than when they have been discharged, because then you've got to just kind of chase your own tail a little bit to get the professionals who are dealing with them. So there'll be like discharge meetings, I'd imagine, in the hospital. Those are kind of really good opportunities to make sure housing are there and kind of make sure the information is kind of to hand that's going to be needed for subsequent assessments. So yeah. Right. So just trying to keep track of everything. So someone going to make a homes application and they're entitled to a one-bed property, but suffer from mental health issues in terms of depression, anxiety. Can they offer me a property with a garden? Due to my health, I need a garden. Can they offer one person a house with a garden as I need due to my mental health? So they can do. I mean, some properties, some one-bed properties do come with gardens. Not many, but they can do. But you're gonna need a really sort of outstandingly strong medical information or medical, like an OT report potentially or something like that. I'm not quite sure how you get that before you have got that far, but you need something really, really strong to say why you need it. And if you can do that, if you can say this person genuinely does need it, then yeah, you're in the ballpark of getting it. But I would say most health professionals, I don't know, it's something which it's difficult to evidence that really. What mental health conditions are there that you absolutely need something like a garden? You might say we need recreational space, or you might need somewhere to kind of be, quiet, or kind of have some peace and quiet. But there'll be other ways of achieving that. So, yeah, I would say it's a big ask. Depends on the local authority, I guess. Some local authorities might have more scope to do it than others. But I imagine making that argument in a London council, even with a decent barrister or whatever, you're going to really struggle to make it. So, I mean, again, it's kind of, they should assess what, part of that initial process of taking the homeless application, then carrying out the assessment. One of the things is what type of accommodation is this person going to need, and then what sort of support that person can need as well to maintain it. So it should be addressed. And as I say, technically it could be a need, but it's more likely to be seen as a wish. Now, I know there's kind of a lot of LGO stuff, not a lot of it, but there's some mention from the LGO and other places about councils mistakenly saying that, that's just a wish, that's not a need, you just want that, and they've been found to be wrong about that. I think in the YR case with Lambeth, I think they said that they kind of made that mistake of saying, you don't really need that stuff, you're just saying it because you want it, and they got pulled up on it. But again, I think it's really difficult. I think I wouldn't have much confidence at all going in with that unless there was some unusually kind of specific aspects to your depression and anxiety to make that argument. So yeah,
I think I agree, to be honest. I don't have a huge amount to add. I think, say if you had anxiety that was sort of at the extreme end, where actually you never left your property, like ever, and you literally can't go to the local park, you can't go to the shop, you can't leave your property, and that people do suffer with that level of anxiety, and you had doctors that were sort of backing that up, and actually part of your treatment or what have you is doing that in a safe space in a garden, and sort of that exposure, whatever it might be. And again, I think this is quite like a niche sort of treatment and everything else. But, if you are that sort of level and what have you, then I think as long as you've got the letters, again, from medical professionals that are saying actually this is a need, like you say, and not a wish, because it's so difficult, because you can't just screenshot the NHS website on this one, because everyone says for your mental health, go take a walk, go outside. So everyone would like that, but they do exist. And again, depending on your relationship with the council, sometimes having an honest conversation and actually saying this isn't a need, however, this would be really beneficial for me, or actually you know, whatever it might be, I think having a conversation with them is probably the best way, and being honest about it as well, because obviously, you know, you can't knowingly mislead them, if you know, and that sort of applies to the type of accommodation you're asking for as well. If you're found to be lying about that, it's, you know, I think, is it a criminal offence, Mike, to lie about that aspect as well, because you'd be misleading them? I don't
Well, I'm
know,
trying to
but
think. It's section 1. It's section 214. I'm trying to think of the wording. It's like a. I mean, we can put it up in a minute. But so I mean, I think whatever, you know, whether it's a criminal offence to kind of to lie about the type of accommodation you need or not, I don't know. I think it probably is a criminal offence, to be honest. But not that you're going to get prosecuted for it. There was a case recently where there was a similar sort of situation. So basically, a guy had some genuine needs through a disability, but he didn't supply. You know, he basically, I think of one, the way I read it was that he was kind of over egging the evidence. He wasn't able to support that, and it's not like, I think it was Westminster Council, but it wasn't like they, you know, they went after him to prosecute him, but they just didn't give him the right house that he wanted. So
just to
yeah,
clarify, I'm not saying person in the chat is you lying, just to clarify.
yeah.
At the same
No,
time, it's important that people realise, because I know certainly in some systems of local authority services or what have you, people, you know, you have to fight so hard for things, and you're told to do that. I think this is potentially one of those situations where you just want to be a little bit careful. Just to clarify, I'm not calling anyone out.
Yeah, no. So I think it's another really good point. So when I worked in Bedford Borough Council, like, I guess I'm thinking aloud a little bit, so I'm probably going to be a bit clumsy, but if someone was seen to be, if a housing officer's like basically saw that or thought that someone was just trying to try it on and being difficult and, you know, stamping their feet and stuff, then I think they would get treated worse. You know, I think housing officers are really kind of sensitive to any sort of like feelings of entitlement, even though you know, it's weird because you're entitled to support under the Housing Act, and it shouldn't be like controversial to act in your own best interest. But I think a lot of housing officers really struggle with that concept, and they're like, you know, oh, this person's, you know, they just need to kind of, you know, beggars can't be choosers, that sort of attitude. And if you try and, you know, go for a particular type of accommodation or whatever kind of specific thing you're going for, you have to be quite savvy about how you do that. And I think, as Shannon says, you know, that kind of having an honest conversation, saying, look, do you know what, you know, maybe I can't provide evidence that I absolutely need it, but it would really help me out. You know, I have got some really kind of significant mental health issues. Is there anything that could be done to kind of give me a bit of, you know, help trying to find that type of combination? I think that's probably more likely to be, you know, there's a probably better approach than trying to like twist their arm. That doesn't tend to go down too well. So yeah. Currently living in, just tell me if I missed anything, Shannon. I'm just trying to keep an eye on the chat. So currently living in temporary accommodation and being moved to another one, but it's council owned. I have a dog and I've been told no dogs in the council temporary accommodation, but I have had permanent council place. I'm allowed to have my dog. How do I get around having my dog live with me, my partner and children in the temporary places? My dog is currently staying with my father-in-law. Okay, so we've talked about this before. It's getting increasingly difficult to make this argument. So councils absolutely can house you with your pets in temporary accommodation or interim accommodation or whatever. And the code of guidance is interesting. This is something we've already talked about today. So code of guidance says that councils, you know, should take seriously the, people's needs for their pets. You know, they should try their best, basically, but that is very far short of saying they have to do it. Now, you can make an argument based on the protection of property, you know, duty. So councils have a duty to protect your property. If I think it's even as soon as the relief duty is triggered, you know, they've got a duty to protect your property. But that would include your pets, including a dog. But these days, think like charities like the Dogs Trust or Dog Trust or whatever, you know, they say, oh no, sorry guys, we'll take your dog for you. And immediately that just gives the council a get out and say, oh, you know, we can arrange for the Dogs Trust to take your dog. And therefore they can, you know, they can kind of evade that, you know, that kind of duty. Now, so again, it's probably very place specific. In Bedford, we've made this argument before, and the council's found places that can take dogs with good outcome. Again, other councils probably might not be so helpful with that. I remember one housing officer I dealt with was like, you know, we really care about dogs. You know, I've got my dog. I would hate to be housed away from them, so we're going to do everything we can to house this family with a dog, and they did it, and it was a good outcome. But so you can make the argument and say, look, yeah, protection of property, but they'd probably also say at this point, well, it's okay because they can stay with your father-in-law for the time being. Which again,
So
I think it'd be difficult to come against that.
I was just going to add, I think, so I was reading it the other day, I think the protection of property thing only kicks in if the applicant is unable to deal with it themselves. So to be honest, if the dog's staying with your father-in-law, the council would say, well, you've dealt with it yourself, therefore we don't have, that duty doesn't kick in because you're able to deal with that. Now, obviously, if, I don't know, your father-in-law's allergic to dogs, then potentially you've got a sort of reason there. But again, I think, yeah, I don't know if it would kick in necessarily in this situation. Yeah, exactly. It's a long shot.
Very, but I mean, not out. I mean, I've just flashed it up here. So this is chapter 17 Code of Guidance. Housing authorities will need to be sensitive to the importance of pets for some applicants, particularly elderly people in rough sleeps who may rely on pets for companionship. Although it will not always be possible to make provision for pets, the Secretary of State recommends that housing authorities give careful consideration to this aspect when making provision for applicants who wish to retain their pet. It falls short of saying they have to do it. And what that means is if you've got a council who's not sympathetic and doesn't have the resources, then you ain't going to win this one, basically. But it's in the Code of Guidance. So it's, just kind of, it is something, it's completely reasonable to ask for it. But as Shannon says, I think the council would probably quite rightly say, you've got somewhere for the dog to go in the short term. And hopefully down the line when you get your permanent place, you'll be able to have your dog back. So I think it comes down to, I think some councils generally can't deal with that. It's just too far to kind of, or too much to actually be able to supply that type of housing. I think for other councils, it's just another way to kind of gatekeep people, or not gatekeep, but put people off making an application. When we have a person who's rough sleeping and says, "Oh, I couldn't possibly be away from my dog." They're like, "Great, well, we can only house you out without your dog." So that they know that person's likely to then give up and just go back to the streets.
Again, another real long shot is if you, and I feel like people don't do this a lot because it's quite intimidating. But if you were to ask the council why I can't have my dog in the temporary accommodation, they'll probably say something, well, it will cost us to remove the dog hair when you leave, or whatever it might be. So then potentially you can have a conversation and say, all right, if I put in writing and we have an agreement that at the end of my temporary accommodation stay, I pay for cleaners, or I pay a nominal amount every month as like a pet surcharge. And again, obviously, I'm not aware of your financial situations, but if you ask them why, then you can open up that dialogue a little bit and potentially come to some sort of compromise. And it might just be, it is a long shot, but
so when you're desperate, anything's worth doing. I mean, it might be worth asking the council if they've got a policy on it. I don't think the councils I've dealt with have got a policy on pets. But it's not an unreasonable thing to have a policy on pets. Like, there should be a fair way of working out how they deal with the issue. But as I say, it just depends where you are. I've worked with numerous households where they've been housed with their pet. Sometimes and sometimes with the council initially said they couldn't do it and actually push them a little bit, and they can. I know John Allen at Just Us in Bedford is basically he's going after the travel lodge, because normally travel lodges will take dogs, at least anyway. But in Bedford they've got a contract with the council which says that they can't take pets. So John's like saying, well, why? What's the thinking behind that? And is looking to challenge it. So I think if you're a professional, it's something it's completely reasonable to go after and raise it as an issue. Because, as I say, if nothing else, the Code of Guidance does say that it's a valid thing to be worried about and want to kind of deal with. So next question. In fact, if we just quickly go to one of the ones that's coming through the week, just so we kind of pepper it up a little bit. I'll try and pick a quick one. So, okay, no, that's not a quick one. Let's just do the one in the live chat. Yeah, the ones there are like not quick ones. Someone has an autistic child with ADHD also and mental health issues and are about to be homeless. So CAMH is involved, which is the Children's Mental Health Service, and have written letters to advise we can't live in flats with people above or beside us. So council refused to accept us for a priority for a house. So
I think as well, they've also had OT write a letter. I think that's an OT have also, so Cam H and
oh
OT.
yeah, sorry, yeah, cool, yeah. And so okay, we might need to unpick this a little bit because loads of jargon in housing law. That word priority it confers different things in different times. So I just need to just first of all work out. So priority for a house, does that mean that the council is refusing to accept that you guys can only be in a house? So as in you would only need to bid on houses on the housing register if you're in the bidding system, or whether it be, what band. I'm not quite sure. I would say that's probably more likely to be the council is refusing to accept that, they would only offer you houses, or you'd only get into trouble if you didn't bid on houses. So I think let me just give a couple of answers about this from my kind of casework. So I'm trying to think of two families, so single mums with kids. One, they were housed, or they were attempted to be housed in a block of flats, like a tower block, like 10 floors or 14 floors or something. And the mum had vertigo, and that was evidenced by the doctor, by a GP. And so initially, council effectively said, no, you're going to have to take it. But then the GP let was enough. And I think within once it gets to a court, councils need a really good reason to sort of disregard medical opinion. But in everyday practice, they often will. So certain doctors, they'll disregard, say, oh yeah, that doctor always says whatever the patient wants them to say. So I think it's a big thing for council to go against that. They might be able to get a medical advisor to sort of say the opposite, which is quite often what they do. But again, it's something that you can. I'm trying to think if you can make them do it. I think if again, it comes down to highlighting the fact that the child has disabilities in the form of autism and ADHD, which if you flag that with the council, which sounds like you have, and also said what kind of reasonable adjustments they need to make, then which sounds like you already have, then that means there's a much kind of more rigorous process the council have to go through to assess those needs, and they would need to evidence, for a start, they need to evidence, if it came to court, like, how did they say that family's request was unreasonable, which would be difficult to do. I'm seeing, just incidentally, I'm seeing a lot of cases at the moment come through Nearly Legal and other kind of places where the council's failure to properly assess things and kind of keep a paper trail of how they assess these different things was their undoing. It wasn't even that necessarily they were wrong. They just literally weren't able to evidence when they made an assessment or how they considered something. So you can certainly challenge it. I'm just trying to work out whether there'd be any kind of, what kind of letter or what you're challenging it under. You could challenge it down the line. So if they offered you a flat, you could challenge it at that point, which is very dangerous kind of situation to be challenging them, because they can, if you lose, then they would end their duty to house you. But you can make it at that point. I'm not quite sure whether you'd be challenging the council's policy or what you'd be challenging at the moment. I guess. Go on.
I feel like they'd be, because there's another comment coming, we're only allowed to bid on flats. So I feel like actually you'd be challenging the housing allocations banding that they've given you. So it's probably worth looking at the housing allocations policy for your area, seeing what banding you've been given, which you should have in a letter or on your sort of home options, choice based, whatever it is called in your area. It should be on your profile. And then saying, put that in an email. So I'm currently banned, blah. I have looked at the allocations policy, copy and paste it, and sort of say, I tick this box, and this box. So I actually feel I should be in band A, for example. So you're telling them why you think you're in the wrong band, and then just attach the evidence that you've got from the OT, attach the evidence you've got from CAMH, attach all the evidence you have to sort of make those points. And then it would be very difficult to sort of to see that. They've just put a couple more.
I'm just
home seekers.
So
obviously every banding in different local authorities, they're all different. So like some councils use A to E, some councils use various letters like that. H means home seekers, other councils use numbers, some use gold and silver. And so without knowing the sort of local, your local authorities' housing allocations policy, it's difficult to know what you should be in.
I mean, yeah, part of the answer would be you just Googling your local housing allocation scheme, and first of all seeing if there's anything in that policy document that kind of talks about this at all. I mean, I think if they're saying that you're only eligible to bid on flats, I can't imagine there's no provision in the area which other than a flat. I'm just wondering if you might be able to challenge the personalised housing plan and the assessment earlier on than this. I'm just trying to look at the code of guidance now to see if you could challenge the assessment now. You can certainly challenge it in certain situations. I don't know if I'm going to be able to pull out the bit I need right now. But I think, you can challenge reasonable steps at some points. I'm not going to be able to find it now. I mean, let me just flash out what I'm looking at, just so you can get an idea of where I'm looking. So code of guidance, again, you just Google a PDF and it'll come up. So the first thing that council need to do once they've accepted that, you're homeless, is to carry out this 3-point assessment, which is assessment of circumstances and needs. So they need to assess the circumstances that cause you to be homeless, what their housing needs are, so it would come. So what we're talking about here would come under this. What accommodation would be suitable for them, their household, and anybody who might reasonably be expected to live with them, and the support that would be necessary for them to sustain the suitable accommodation. So I'm trying to work out, I don't know if there's a statutory right of reviewing that or challenging that assessment, because you could at that point say, well, hang on a minute, you haven't, you could let's go back to basics. You can do a subject access request to request a copy of all your notes from the council. And in their assessment, they should have, specifically said, we're looking at the needs of the child. They have got autism and ADHD. There's OT assessments or whatever coming in saying they need to not be housed in a flat. And here is why we're discounting that. I think they wouldn't have done that. I think they would have failed to actually give a good reason why they're going to disregard that information. So another comment here. So they inform me houses are only for people downsizing. This could be a really this could be a case of indirect discrimination. There's various, because in one sense it's a policy something or practice, PCP it's called. This is not my area of expertise at all, but basically if you've got like a housing policy which is giving these kind of blanket, this type of accommodation is for this type of person, this accommodation, you're all, so in one sense you're discriminate, you've got someone with a protected characteristic probably in terms of autism who is getting is not getting a fair kind of access to services that others would do. And I don't know whether this kind of idea would transfer to this particular situation, but to give you an idea of the kind of things that would happen. So there's a council called ADUR, ADUR, I don't know how to say it properly. It's down on the way to Brighton, between Brighton and London, and their policy was challenged successfully. It was found to be unlawful in terms of it being discriminatory, because if you were a victim of domestic abuse where you're more likely to be female and therefore it's a protected characteristic, you are restricted in kind of your access to the housing register because you're fleeing from another area, you don't have local connection. So it's kind of a various step kind of process to establish that it was discrimination. But there's another case that Sarah Steiner talks about where, as I say, for good reason, counts. I think it was Birmingham. They basically said that houses would be always kind of kept for families with children because that's it's good for families with children. But where you've got someone with a disability who has a genuine need for a house, they would immediately getting kind of cut out from that, and that was again found to be unlawful. So I wonder if it's not something that you could probably do when you're dealing with it yourself, but I think if you can get a decent advocate or potentially a solicitor to look at this, it might well be challengeable.
I think potentially as well. Sorry.
No, you're gone.
Contacting your local MP, and again maybe because I know sometimes we talk a lot about make a complaint, challenge this policy, point out that this is discriminatory, and that we're to some level used to that sort of thing. We're used to looking for allocations policies. Actually, I remember the first time I had to read Bedford's and I was like, no. So it's not always reasonable. So I think if you can try and talk to your MPs, but potentially just write an email to your housing committee, and that's literally just put your situation, if you're comfortable with that, of course. And you can take away certain information. You don't have to sort of have your name and stuff, but taking your situation and saying to the housing committee that are full of sort of local councillors, is this okay? Are you guys comfortable with the fact that your housing allocations policy, or I have in an email that houses are only for people downsizing, are you guys okay with that? And sort of getting them to stop and think, and then it might be enough to get them to help reassess. And again, MPs can in some situations be quite useful to pull in a bit more strings for you.
Yeah, I mean, it obviously depends on the MP, and so technically MPs have no hold over a council. Their job is to go and represent the population in Parliament. But obviously a good MP and their team will be good at challenging these kind of issues. But councillors are kind of, they work for, I guess they do work for the council. They get paid by the council. So yeah, so they do have much more hold. So again, you might get lucky with a decent councillor and decent MP as well, who you can just explain it. And if you're going to go to him, I would just kind of say, look, I don't know for sure, but this might be discriminatory, because there might be people who have a disability who need a house and who are automatically cut out from the possibility of having a house because your policy is kind of favouring people downsizing. Now, there's a reason why to prioritise people downsizing, because it frees up housing stock. So it's not like the council's evil or anything like that. They've got good reasons for doing it, but they may just have overlooked that actually some people need a house, and their policy is kind of inadvertently cutting those people out from that possibility. So yeah. Next question. So we do have email addresses, obviously, but we don't give out advice, or we don't engage in any casework. So we have other jobs and other things going on. So this is kind of very much a part-time thing for us, or a spare time thing probably. So we're not able to kind of do casework. We try and give out information as much as we can to help people, but we're not able to take on individual situations and be contacted. So back to the questions that came in through the week. Now, as I say, none of the ones left are particularly straightforward. I'm going to do this one here. Didn't even come to us technically. It came through the Facebook group, so we've already kind of answered it in the Facebook group. And the Facebook group is specifically for professionals supporting people who are homeless. So if you've got questions about your own situation, Housing Advice UK, Housing Advice Independent are both reasonably good. I do see a lot of bullshit in there in terms of people just being treated really badly. I saw quite a funny one this week where someone was asking a question about the situation, and they're kind of saying, well, I can't move here unless this day because I'm accepting a delivery of a car or something. And then everyone was like, oh, if you've got a car, you're getting a car delivered, then you must be all right. She's like, it's a company car, and I have, this is the real thing. But yeah, you do get a bit of kind of judgment and a bit of unpleasantness sometimes in those groups. So if I was you, I'd do it as an anonymous questioner. But the group we run is for professionals, and let's be honest, people who just ask questions as if they're about someone else, same as we're doing tonight. So there are people who are homeless themselves in there. But this question came up. Long story anyway. The question came up. So this particular individual had been found to be non-priority, even though they've got COPD, so a respiratory issue. And specifically, the housing officer said that for them to be in priority need, they must be on 3 or more inhalers and, kind of under hospital respiratory clinic and blah, blah, blah. So they kind of set this very clear criteria. And I just want to raise it here just to make the point. When it comes to assessing vulnerability, there is no one size fits all. There's no rule that says, you need to be on X number of inhalers. And if you're not, then you're not vulnerable and therefore in priority need. So this approach from the housing officer is automatically unlawful, but that doesn't actually win the argument. So you could request a review of that non-priority decision. It would go to a review officer who might say, yeah, actually, do you know what? The first officer did make a mistake. They shouldn't have applied that one-size-fits-all approach. However, I'm still going to say that you're not in priority need. So that does happen sometimes where, I can't remember what, I think the technical term is that the review officer would set aside the original decision, but then go ahead and make exactly the same decision again, just for different reasons. So I'm not going to answer this in any more detail because there's lots of information on our YouTube channel about vulnerability and how vulnerability works. But I just thought it was an interesting point to see housing officers do that. I don't know, about 10 years ago, I saw like the notes from Now Medical training they did, and they did have quite a tick box exercise approach. It wasn't technically, but I think it would be read by housing officers to be tick box. So it'd say like, X condition, they probably are in priority need, Y condition, they won't be. And that's the wrong approach. You need to look at the whole individual and look at how their particular condition would be affected by homelessness. That's kind of halfway there to getting the test done. So that's that question there. So we've done some of these already, done that one. So this is a question here, just very similar to a lot of people. Just, you kind of approach the council, now you're getting nothing back from the council. Council officers are busy, but that's because the council hasn't, kind of given enough resources for the housing officer, so it's not your fault. So if you don't get a response from housing officers quick, in a reasonable period of time, then just escalate it, complain, copy in their line manager, go to a councillor, go to an MP, because housing officers should, they should be resourced, and they should have enough people there to actually give you a timely response when you need to know stuff. As a result, housing officers quite often miss like really good opportunities to prevent someone being homeless because they're just overworked. So, again, if you're an advocate, something we've had a lot of luck, me and Shannon in Bedford, is we did an FOI, I think, started off with an FOI, freedom of information request, where we asked what the caseloads were of housing officers, and we were able to show that it more than doubled in a few years. It's now got even worse, actually, but what they have got, if I understand it correctly, is they've got funding for another 20 housing officers. Shannon might correct me on that, but that's so something like 20. So that's an example of where Joe Public can go and ask a question in the housing committee. And housing officers, I think there were fans for doing that, because they were like, completely snowed under. And the fact that someone was able to go around, kind of around the system, around the hierarchy, to go and ask for that was a helpful thing to do. So I think it's probably one of about 20 questions we've got, which anyone can ask at any council, and it will probably lead to an improvement. So Shannon and I have done a series of videos recently. We're going to do another one soon, just based on those questions that we ask in the housing committee, and kind of friends of ours asking the housing committee, just kind of what impact it has. Again, Shannon, you could correct me on this, but a few years ago we asked a question around why did the council not have wheelchair accessible temporary accommodation for people who had a wheelchair? And at the time they were like, we don't really know. And then lo and behold, a couple of years later, they've now purchased temporary accommodation that's wheelchair accessible. So you can raise, as long as you're raising a sensible issue, you can get really good results without having to kind of get into a spat with anyone and have a fight. You just kind of do it publicly. Making this stuff public is really important. That's another question for another time, basically. So right, so I think I can answer this question. So the council is basically saying they can't accept a homeless application if you don't provide kind of a letter from the family member you're staying with. So this often happens. So you're staying with family, you get kicked out from staying with the family. The council then say you need a letter from the family member in order for us to take your application. Now that's the wrong approach. Councils have to accept the application as soon as there's reasons to believe that you might be homeless or threatened with homelessness. So that would kick in the moment you say, I can't stay with my family anymore, they've asked me to leave. That's reason to believe that you might be homeless. If you don't believe me on this, there's a video on the YouTube channel. If you Google, or if you search on the channel for 3 Judges Explain Section 184, I think is the title, something like that. You've got Jan Luber, who writes the textbook on housing law, and 2 other judges just talking about, how easy it is to trigger this duty. So it sounds to me that the council's acting unlawfully, so you can complain about it. I guess the question would be is why, in pragmatically, why not just get the family member to write a letter that you can't stay there anymore? You shouldn't need to, but in the circumstance for you, it's probably better that you do that. But yeah, that's as I say, that's gatekeeping. They've basically applied too high a threshold on accepting a homeless application. But as Will's kind of said before, he's made this point a number of times. It might well be you can prove the council lying or acting unlawfully, but that doesn't help you. You need to work out how to get the council to follow the law. So either get a letter or complain about it to the chief exec and just say, look, I've approached the council for help. I can't get a letter because of X, Y, and Z reason. They're refusing to take the application, and just kind of take it from there, basically.
So it's important to note as well, sort of, obviously you have to ask for help as well. So you have to say I'm homeless and you want some sort of assistance with that. But also I think, and I'd be reluctant to do this at such an early stage in the sort of like process with the local authority. But potentially, if they're refusing to sort of tell you whether they've accepted Section 184 or what they've done, do a subject access request, and ask for the information that they've got, you know, on you around housing and your homelessness situation. They do have to provide that for you. Obviously, it would take 30 days, potentially longer, very likely to be longer if we're being realistic. But that is, you know, that's another legal right you have under the Data Protection Act, is that you can request that information. They have to give it to you, particularly if you're going down a complaint route. And again, I would be so reluctant to do this at such an early stage of the process. If you can go around it a different way and do this later on, it's still worth doing. It's still worth complaining. It's still worth doing the subject access request, but they're instantly going to get that backed up if you do it at the beginning. Definitely still worth doing, but yeah.
Yeah, I think if you're, so if you are if you says here, yes, if someone was locked out from the property, then I think you would email the council saying I'm locked out from the property. You know, I can't get a letter from them or whatever. And if they fail to deal with you, then ring out the emergency out of hours team and say, look, I've got a kid been locked out from a property, housing's not accepting the application. And hopefully the social worker who deals with that would have people sensible. They should be. If there's a child about to be sleeping rough, they shouldn't need telling. Having said that, one of the case studies we use in our training is based on exactly that, when a social worker had been told by housing not to house a family, and as a result, kids were sleeping rough. So it does happen, unfortunately. Again, see if you can find a decent advocacy service in your area. See if there's someone who might be able to help out. If the council's unhelpful, if you're literally sleeping out with a kid, I guess go to the police. If the social worker, if the emergency duty team has said, you know, we won't house you tonight, then potentially go and just park up in the police station. Again, it's not, you shouldn't have to do it, but that's what I would do in that situation. And then try as hard as you can to find a solicitor that gets legal aid. So Will Flack, he's got a list. In fact, if I'm clever about it, he's basically published a list of housing solicitors who can take legal aid for homelessness cases. Yeah, I can't multitask here, but if you Google it, I'll see if I can get the link and put it up in the chat. Yeah, or Shannon, if you're better at some multitasking than I am, then you can do it. And here we go. I think I've got it. Here we are. Somewhere I've got his website anyway. If you just go wflack.com, somewhere on there, I'll find it in a minute. Anyway, that's a list of solicitors you need to get on the phone to, basically. Yeah. So I mean, yeah, just to reiterate, the information that's coming through, the family member's not wrong. You know, you don't have a legal right to say that if they've removed or they've kind of denied your entry to the property, you've got no legal right to live there. The council should be accepting the homeless application already. And if you've got a child, then there's reasons you might be in priority need, obviously, so they should be offering interim accommodation immediately. Thanks, Shannon. Oh, yeah, cool. Just right, hold on a sec.
It wouldn't let me post it in the YouTube thing. So if you're able to copy and paste it into you.
Yeah, that doesn't help me either. Hold on a sec, because that doesn't help me because I'm on two laptops and I can't copy and paste it.
So it might be worth if we put it in the description afterwards.
Yeah, let's do that. We'll do that. We can do that. That's cool. All right, cool. Yeah, so list of contact numbers, basically. As I say, there might be more that Will's not aware of, but it seems to be a pretty comprehensive list. So how are we doing for time? We're doing well. We're coming to the end of the hour, but let's check there's no other questions that come in. So there's no other questions on the live chat. Let's just go back to the question we had before, just make sure we've not missed any ones which we need to do. Okay, so I'm currently in a house share through the council, living with other tenants. The house is not safe as we've had threats and people showing up. I'm genuinely in fear of my life. Police have been here several times. Would I have a strong case for the council? Now, I assume you mean a strong case to make a homeless application or get rehoused, I guess. The answer is no, but you do have a case for sure. I don't know if it's a strong case. Now, there's a bit of detail here that makes me think this is probably a rent deposit type property. So councils work with private landlords who will often be HMO landlords, and the council will help assist people into a tenancy in a shared house. And I can't speak for any, I can only speak about my experience in Bedford, but the council, they're kind of responsible for what was going on in those rent deposit scheme tenancies, because part of the deal with the landlord is, that the council will step in if there are issues, because obviously they want to keep landlords on side. And if they've got a property, if they put people into a property which is now, kind of there's some antisocial behaviour going on, or potentially worse, potentially exploitation or safeguarding issues or whatever, then it's in the council's interest to basically be responsive to that. I've certainly worked in cases where they rehoused everyone from a HMO into temporary accommodation because there was cuckooing going on. So I think the first point of call would be to contact whoever it was that put you in there, assisted you into that HMO, and just explain what's going on. Explain the kind of incidents you've dealt with. If you've got police crime reference numbers when they've attended, then throw them in. If you've got police names, then throw them in too. And hopefully the council will be, they've got, they need to be seen to be responsive to those kind of issues. Now, whether you can make a homeless application, you could make a homeless application as well. You can always make a homeless application. You can always try anyway. You can always approach the council and say, look, this is where I'm living. I feel completely unsafe because of what's going on here. Here's some detail. You want to give as much detail as you can. Can you help me with getting rehoused? That, that may well trigger a homeless application. It probably would trigger a homeless application. They might make inquiries and say, actually, do you know what? There might be some stuff going on, but we've alerted the SB team and we've talked with the police, and we're satisfied that it is reasonable to continue to occupy. So that might happen, but you can still kind of get get a bit of leverage by making a homeless application. Just to reiterate, low thresholds. If there's reason to believe you might be homeless, then they have to accept the application. And I would say this is certainly in the ballpark of having reason to believe that you might be homeless. It just depends on the severity of what's going on. In one sense, this sounds harsh. In one sense, someone's subjective views about whether they're in fear of their life is either not relevant at all or not very relevant. It's about the objective risk. So, the police might well have a risk assessment. The police might have an opinion about that, which you might be able to get anyway. So, for example, if a police officer's attended and you've got their contact details, you could go to contact them again and say, can you provide some information for the council to assess whether or not it's safe to live here? That can happen.
And again, so depending on, how you're feeling about this situation and how it's affecting you, now is a time that I'd be making a GP aware of this. And I'm not saying, they have to prescribe a medication or sort of anything sort of major, but I'd be making that appointment and saying, look, I've got this huge stress factor going on. I'm fearing my life. This is happening. Now, whilst, no actions might come out of that GP appointment, or sort of an appointment with the nurse is probably more likely is what you'll get, depending on the severity of how you're feeling. But what it does do is it just shows that you're talking to professionals about it. And again, you're building up a picture that if sort of later down the line things escalate or something changes, and then you do become sort of homeless because it is unreasonable to continue to occupy, you've got that sort of that evidence right from the beginning, and you can sort of show how it has affected you.
Yep, cool. The more information you can get, the better, for sure. I don't know if you, I guess technically speaking, if you've got care and support needs, which is a technical term which relates to the Care Act, but it doesn't necessarily mean you need to have a social worker. But if you've got, mental health issues, you could potentially make a safeguarding referral for yourself and just kind of say, look, feel unsafe. I guess it would depend on the nature of what's happened with the people showing up and how severe it is. But that it could be relevant. If they've damaged your property, or if they've caused you alarm, distress, or whatever, then potentially that might be something which a safeguarding alert would pick up on. And again, it's not an unreasonable thing to make, to approach safeguarding team. They might say, well, you don't meet our threshold, that's fine, but at least at least it's worth doing in terms of just trying it. I've just put the Will Flack link on the live chat. I'll stick it on the actual description as well, which is that list of solicitors that can take legal aid for housing cases. So there's one final question that we haven't done yet from that came in through the week. So this is your last, if you have any further questions, now's the time to ask, because we'll probably be shutting down in about 5 minutes or so. So the final question is a really interesting one, which is probably going to be of more interest to geeks out there, because it's quite obscure, but it's an interesting kind of case to discuss. So what's happened is, I'm just updating a few things as well. So what's basically happened is father, mother, and at least one child, children it sounds like, have made a homeless application, and the council has accepted that they owe them the main homelessness duty. So they have they're going to get housed in private rented or social housing at some point. But in the meantime, they're in temporary accommodation under Section 193. Lots of jargon there. Hopefully you're still following me. Now, the application was made in the dad's name, and he was in priority need because he had dependent children in the household. The couple, I don't know if they're married or not, the couple then separate, and the question is, what happens to the homelessness application, and what options do they have? So there's a few interesting things going on here, which, as I say, it might be of interest to people just to understand how the law works. One interesting thing is that if the council find you to be in priority need and then you lose that priority need, that doesn't change the fact they owe you the main homelessness duty. So give me an example. This is, I guess, it's a bit of a sad example, but say you were pregnant, you made a homeless application, and the council did their inquiries. They reached a decision that they owe the main homelessness duty, and then you had a miscarriage, let's say, so you're no longer pregnant. The council will still owe you that main housing duty because they'd already reached that decision. I've seen before where councils will delay making that decision, for example, because it might be because the children are going to be removed from the parents' care when the child's born. So when you've got parents or a parent who, for whatever reason, is not going to be able to kind of meet the needs of the child, social services won't tell the couple, the parents that, because there'll be a risk of them absconding or whatever. But they may well tell the housing officer. It shouldn't be decided until it happens. But the housing officer will have a good idea whether it's likely that baby will be removed from their care. I've seen housing officers delay making the priority need and main housing homelessness decision until after the children are removed, so they then lose that priority need, which is harsh. It's not lawful to do that. You have to make decisions within a reasonable, kind of the reasonable time. But that's kind of just shows that, once that duty is owed, it sticks with you. Now, in this case, it would, as far as I understand it, and I'm happy for someone to correct me on this, but it would basically apply to the dad because he was the one who made the application. But if the mum leaves him with the kids, he might not have a priority need anymore, but he would still have a main housing duty owed to him. Hopefully you're following me so far. It gets a bit more complicated now, though, because if the mum was then to make a homeless application in their own name, which she could do, I think what would happen is the council would say you're not homeless because although you're not in a relationship with the dad anymore, we consider it to be reasonable for you to continue to reside with him. And that would be the case if there was no domestic abuse involved. If there's domestic abuse involved, then it would be much more straightforward. But this goes back to a case which is like 25 years old. It's called Moncada or Monsada or whatever. And in that case, basically this couple, the guy went into prison for 3 years or something. The woman continued to live in the property. And whilst he was in prison, she broke up with him and entered into a new relationship with another guy and moved him into the house. When he was released from prison, the judge said, it's reasonable for you to live together with your ex-partner and her new partner, which I think is ridiculous. It's one of the few ridiculous things I've seen in housing law. But that's the kind of position, as I understand it, still even now. As I say, it'd be very different if there's any domestic abuse involved because the mum would be owed a duty anyway. But so I think, as I say, it might seem like a bit of an obscure question to talk about, but I think there's kind of two potentially interesting principles from that, where the duty is, one person makes the application with the family as part of the household, So, you know, another, you know, the family could break up or whatever, and someone else could make an application in their name. But in a situation like this, where you might have a so-called civil relationship breakdown, then they would be expected to live together still. Now, again, I'm happy for anyone to kind of correct me on that in terms of how it might work out in practice, but I think that's how it would work. But yeah, so I'm certainly, you know, the Moncada case is real, as is the ability to, you know, to the fact that the duty is owed to someone. Once it's owed to them, it sticks with them, even if they lose that priority need down the line.
I mean,
So, oh, sorry, Sharon, go on.
Yeah, I'm just being difficult. If that was a situation though, and say, yeah, no domestic abuse, but actually after 3 months, it was making, I don't know, the dad's diagnosed depression real worse, real bad, or his anxiety really bad, are we not then in the realms of sort of Lomax again, where actually then it would become relevant? So even though there's no domestic abuse involved, if it's having a substantial impact on your health, that, you know, and you've got a disability, whatever that might look like, or potentially even, you know, say a physical disability where, you know, your partner was your carer, and actually it's inappropriate for them to wash you now, or it's inappropriate for them to dress you, those sort of like more intimate caring activities, I wonder, I don't know, I'm being difficult, sorry, but
No, you're right. You're absolutely right. I think it's just, you know, and I think it would not be difficult to imagine a situation where that situation, it just gets untenable very quickly. Now, I would say, I would imagine that a lot of housing officers would say, yeah, do you know what, fair enough, we'll take the fresh application. So the dad would get a 1-bed flat rather than a 3-bed house or whatever, a 3-bed flat. So I think most housing officers would say, yeah, clearly this is unreasonable. But as I say, that Moncada case, in my mind, was unreasonable, and that's what the case is. I don't think there's been I don't think that's changed. So, yeah, so you might be into the, as you say, making that Lomax argument, but again, it's that very high threshold, which without a solicitor, I think you've got very little chance of winning. So, yeah, hopefully that's interesting. Or as I say, hopefully that helps people understand how this kind of works, like that kind of that process. So, unless there's some very last minute questions, we're going to call it a night. If you are, so in 4 weeks' time, 4 weeks today, we're going to be running our ethics of gatekeeping event. We've got a really cool panel. We're going to be announcing who the panelists are shortly. So do come and follow us on Facebook or whatever. I think that's where we kind of say stuff first. If you haven't already, subscribe to the channel. That'd be really help us out. And also, there's a little red arrow down the bottom right of the screen. If you just click on that, you should subscribe. If you want to be super fan, you can subscribe to the notifications as well somehow. I don't even know how that works. And if you want to like the video, then great, that would really help us out as well. But yeah, do keep the questions coming in. As I say, hopefully this is just helping people understand, just getting around the jargon, because it's just utterly confusing. And yeah, as I say, I don't know if Will's here next week. Shannon, are you about next week? So yeah, we'll be back next week. The one thing I'd ask, actually, if you guys have got an opinion on it, is if you could contact us, probably through Facebook. Just send us a message on Facebook. I'm specifically interested right now about what it's like to be gate kept. If you've been gate kept yourself, what was that like? You know, did it do you any damage? Did it do you any harm? My guess is it probably did. But what impact did that have on your life? You know, obviously you may well have been homeless as a result of it, but how did it change how you interacted with services? How did it change your outlook on life? I think these are all things that might kind of be, might kind of come up if you've been in that situation yourself. I'm asking various questions of various people just in preparation for this event, and I think it'd be just very interesting to hear back what harm that did. You know, that act of kind of denying you housing unlawfully. How did that change things for you? So yeah, follow us on Facebook, Homelessness Best Practice, and send us a message of that. That'd be really helpful. Cool, nice one. Cheers, Shannon. I will see you soon, but we'll be back next week. Take it easy, guys. Yeah, good luck with any arguments you have with the councils. Yeah.